Good morning, everyone. I am Carrie McReynolds, a director with the CCCBA. Thank you for getting up this morning and electing to learn with us. On behalf of the Contra Costa County Bar Association, I would like to welcome you to the 26th Annual MCLE Spectacular and this morning's program, Social Media Management and Litigation, presented by the CCCBA's Litigation section. I hope you enjoyed last night's kickoff keynote when several of our Bay Area Law School deans discussed the changes taking place in legal education. Today, you have a full day of great programs to look forward to, including a keynote with Novella Coleman of Bay Area Legal Aid. Our event and program sponsors are a very important part of our CCCBA community. They make it possible for us to provide events like this. Please support us by supporting them. If you are having technical difficulties, please have a look in the Fact tab to see our troubleshooting tips. For those of you that are not aware what a FAQ is, we call it a FAQ, Frequently Asked Questions. At this time, I would like to pass the program over to one of our excellent presenters, Nick Casper.
Thanks, Carrie. My name is Nick Casper. I am a managing partner at Casper-Meadows, Schwartz & Cook in Walnut Creek. We are a plaintiff civil litigation firm who specialize in wrongful death, catastrophic injury, sexual abuse cases, civil rights cases, as well as other areas, always on the side of the plaintiff. I'm in my 14th year of practice and in my 3rd year of being a managing partner at the firm. I was also on the Contra Costa County Board of Directors for 7 years, and I was the board president in 2015.
Good morning, I'm Jaime Herren. I'm a litigator in the San Francisco Bay Area, and I'm currently with Holland and Knight. I practice complex trust disputes as well as complex asset management. And I've been practicing for about 10 years, and I am currently the co-chair of the litigation section of the Contra Costa County Bar Association.
Good morning, I'm Adam Carlson. I'm also a managing partner at Casper-Meadows, Schwartz & Cook with Nick Casper. And I got my start in litigation out of law school as a public defender for Alameda County. And was there for 5 years before moving over to civil litigation, doing plaintiffs' personal injury and wrongful death matters. And I've been managing partner with Nick at the firm for, this is our 3rd year now. So looking forward to this presentation. Thank you all for joining us.
And let's get started with our slideshow. So today we're presenting on social media management in litigation. And we're going to take you all the way through client intake and case assessment to discovery and where to find social media accounts, all the way through trial presentation of evidence and how you authenticate social media evidence. So can we go to the next slide? This slide is just to introduce you to the plethora of social media that's out there. You can see we have everything from your standard Facebook, Twitter, Instagram, YouTube, to a variety of other ones, including TikTok, which it doesn't really have that textual comment that you would think of when you're thinking of discovery and you're thinking of collecting communications. TikTok is video only. And as you keep going, Amazon has not only purchasing history, but reviews. And then if you even keep going one more time there, you have some athletic forms of social media, things that perhaps have GPS or other types of data. So when you're taking in a case, we want you to consider that there are lots of kinds of social media out there, and you need to be really creative in your fact gathering process and where you're going to find those evidence. You also need to be aware that there are social media platforms that are not popular in the United States, and they're popular in other languages. So when you're asking, say you're dealing with a party that speaks a foreign language or has international family, here's the list of the top 75 as of September 2020, the top 75 worldwide. And as you take a look at this list, you see Facebook is at the top worldwide. Instagram, Tumblr, those might be very recognizable to you. But then you get into WhatsApp, and WhatsApp is communications worldwide that is extremely popular. It includes text communications as well as other kinds of verbal communications. Snapchat, Pinterest, we're starting to get into pictures and the evidence with pictures. And as you keep going, you'll see there's more and more different types of social media. So as you assess a case, every time that you get a case, you need to consider what types of social media it might touch, because that social media might help your case. And I'm going to pass it off to Nick, and he's going to give us some really good examples of how social media touches cases.
So we're in, basically year 15 plus when social media has been kind of a mainstay of our, societal landscape. So we're way beyond when social media is kind of a fringe, area of the internet. This is something that has been a real core part of our culture for a while, and will be in ways that are both increasingly expansive and increasingly unpredictable. As you saw from that list, things like MySpace, which were, the big dog, in the early aughts, is barely, present now. And things like TikTok, which no one had heard of 2 years ago, is now omnipresent. And social media in our cases has to be really thought through, and you will be behind the ball if you're not giving any sort of attention to social media, both using it in your case offensively or defensively from your client. And that's really how I like to think of social media, is using it as a sword in our cases, in which you're using it to prove an element of an issue in dispute, as well as a shield to protect our clients from invasive, overexpansive inquiries into their social media. So first, we're going to get into some specific examples of the ways social media can be used in our cases. So Adam, if you wouldn't mind pulling up a slide. The first area is notice. And excuse me, that's the next one. It's parties conduct. So this can come up in a variety of ways. The first thing that should be mentioned is social media, its proper use in litigation is not to character assassinate or to show someone in an unflattering light, simply to, to needle the opposition. I think that is likely unethical, and it really needs to remain relevant to an issue and dispute in your case. So for example, if you were to have a trip and fall case and you found a social media account of a store employee where it showed them, likely intoxicated at a party 5 years earlier, there's absolutely no relevance to that sort of information. So I would believe, or I would assert it would be improper to use that in any way in your case. But oftentimes social media can touch on a relevant issue. Parties conduct, this often comes up in our practice on the issue of punitive damages. So as some civil practitioners likely know, Civil Code 3294 covers punitive damages in California, and if you're alleging it, you need to prove malice, fraud, or oppression. Typically in our cases, the prong that fits our fact pattern is malice. So you're showing some despicable conduct, and you're showing some conscious disregard for harm upon others. And you're also essentially proving that punitive damages, or damages that are intended to punish, are appropriate in this case based on a party's past or continuing conduct. So for an example, if you had a case where the defendant was alleged to have been in a street race at the time and caused an accident, a single time of street racing, it potentially could meet the standard of punitive damages because it does show a high conscious disregard for harm, but it would certainly bolster the claim if you could show that this defendant had engaged in that conduct in the past. So a look into that party's conduct on their social media, say Facebook, Twitter, Instagram, or any of the various platforms that Jaime reviewed could show them engaging in street racing. Oftentimes in that sort of subculture, you will find videos of the defendant engaged in those sorts of street races because they're trying to, it's kind of a badge of honor to show that, they're too fast and too furious. Another example could be an assault case where our client was physically assaulted by someone and the defendant has defended the case by bringing the affirmative defense of self-defense. You could find social media posts that show that the defendant had a propensity for acting violently with others, which would undermine that defense, that they likely, or oftentimes the aggressor. You still could run into issues about admissibility of that evidence because you're talking about prior bad acts. But as an initial matter, it certainly is relevant as to that defense and would be worthwhile investigating their social media accounts.
In a more boring example, I've used social media against a CPA who we were alleging overbilling against. And there was actually an incident where in the course of this case where he had billed 24 hours in one day. So on that date, we pulled up all of his social media accounts to, we were trying to prove that he wasn't working 24 hours a day. And indeed, he had made several posts on the day where he had also billed 24 hours. So in addition to it being egregious that one would bill 24 hours in a day, we also showed that he was engaging in other types of activities. So, something like GPS data, if he had gone on a run that day, that would have been great as well. But so you could use it in a more boring context as well.
Absolutely. It often can touch on some issue in dispute or some relevant issue in your case. And it is nearly always worthwhile looking into social media accounts of parties involved. One specific example I was going to discuss is on parties' conduct is a case that happened a while ago. When I was going back in preparation for this presentation, in my mind, I was thinking these were Facebook posts. It was actually MySpace posts of the defendant. So that just shows how quickly the landscape can change. And this was, about 10 years ago. I don't even bother to check MySpace anymore. But in this case, the defendant was a recidivist drunk driver. He had a prior conviction for drunk driving and he was leaving a bar allegedly intoxicated, or it was proven he was intoxicated, and he ran into our client and he pinned her against another vehicle and then fled off. So there wasn't really an issue as to whether he was in fact intoxicated. The investigating police took care of that issue and he was convicted. But we had alleged punitive damages because he was a recidivist offender. And to bolster that, we looked at his social media accounts. And once again, on MySpace, we found various public posts. Some of these were before the incident involving our client and some were after. But as you can see from this slide, it shows all alcohol-related conduct. He's wearing a beer case helmet. He's wearing a beer drinking helmet. And the real crown jewel of this evidence was the defendant with a car trunk full of beer posing, making an alcohol drinking sign. So you had the relevance was really ironclad. You had a clear nexus between the drinking and the driving. We presented these as exhibits to his deposition, and it was a real, gasp moment where his attorney had to take a break with him, and the case definitely was pushed towards settlement in light of this evidence. Another type of way that we can use social media as a sword to prove the elements in our case are notice, which I had referenced earlier. This also can come up in a variety of ways. One way that it comes up frequently in our practice as personal injury attorneys is in a case where we have alleged that there was a dangerous condition of property. This could be on private property or on public property. And one of the burdens is to show that the defendant knew or should have known that there was some dangerous condition of property. This could be in any variety of ways. For example, in a slip and fall where there is water near a garden department in a big box store like some store that has a garden department, you could look on their Yelp page and find photographs that show the garden department, and you may see things like water on the floor or wet areas on the floor, and that might be directly relevant to an issue in the case. A specific example in one of my cases was a woman fell from a ledge on the front of a property, and one of the defenses that the defendant property owner asserted was that that she had essentially gone out onto this ledge on her own, that it was not something that any guest or resident did in the past, and that it was basically unforeseeable that she would be out on that ledge. Hence, it wasn't a dangerous condition of property. Similarly, it's like if someone fell off a roof, but no one had ever been on the roof before, your dangerous condition, your premises liability case would be pretty weak because there would be a lack of foreseeability of that harm. We went onto the social media accounts of residents and the friends of those residents, and we found a treasure trove of evidence. In this photograph that was before the fall, you'll see two individuals, one standing and one sitting on the right side of this photograph. That was the specific ledge that the client fell from. So here you had really incontrovertible proof that people were openly and notoriously accessing this ledge, this dangerous condition of property. And as we dug further into the case, we found additional evidence. For example, on the left, you had a photograph of an individual standing in a robe on that exact same ledge. And then this one was more subtle, but on the right side, you'll see at the top of the photograph, the bottom half of an individual kind of straddling between the ledge and that railed balcony. And that was a really important piece of evidence in our case because that was the same manner that our client had attempted to access the ledge, by climbing over the railing and onto that ledge. And once again, they had defended the case initially saying this was not something anyone ever did. No one ever tried to get onto that ledge. And here you had a person in a very crowded setting standing in precisely that manner. So this was really critical evidence in showing that the defendant knew or should have known that people were accessing this area of the property. Other examples that could come up on notice is a product liability case. If someone was injured in a way that was due to the dangerous condition, due to some dangerous defect in the property, although you do have strict liability in products cases, it still can bolster your case by showing that the defendant had notice of this dangerous condition, as well as that other consumers had also been injured. So a typical search that we would do, which does fall into that same category of social media, is on a some sort of platform like Amazon, where you can go into user reviews and go through the comments and find any reviews that talk about being hurt or injured or some sort of defect that is similar to the defect that your client confronted. And you often can do those searches by keyword search. So if you have a product with thousands of reviews, you don't have to individually read each review. There's often a search function across those user comments. And that's just one. You can go onto any platform where people are purchasing, where they're leaving reviews, and find evidence. Another
That's
example.
right. So when you're, sorry, Nick, when you're interviewing your percipient witnesses, this is all on intake, all at the very beginning of your case. When you're wondering where do people purchase this thing, you shouldn't just be thinking in your head, I would go to Amazon. Ask your witnesses what type of social media they use. Because, for example, in Nick's case, where he ended up going on to the building residents' social media accounts. So you need to know which social media accounts the residents use. So as you're doing that intake, as you're learning who your witnesses are, your first contact with any witness or any party that should be included in your typical ask. You know, what kind of social media do you use? Where do you purchase these products? Where do you post your pictures? How do you talk to your friends about this, right? Get those social media accounts, those platforms identified for yourself to make your job easier and be able to, you know, we're going to move into how do you collect this evidence? How do you use third-party subpoenas? Well, you need to know the entity first. So this is where you do that.
Thanks. And just another quick example of how notice in social media can come into play. For example, if you had a food poisoning case and your client had an anaphylactic allergic reaction to the food due to cross-contamination, you might be able to discover some evidence of unsafe food practices in the past prior to the incident or even after the incident on the restaurant social media accounts. For example, Yelp has both restaurant as well as user submitted photos. And oftentimes these are hundreds of photos, and you could discover evidence of, for example, a grill that had cross-contamination where you had shellfish and other items in close proximity. So notice can come up in any number of ways. The last category, and this is by no means exhaustive, is party or witness credibility. I think this one, you have to be the most mindful of that early kind of admonition I gave against using social media to smear an opponent or to use it just to show them in an unflattering or unsavory light. But occasionally, this will come up on a direct issue in the case that bears on their propensity to tell the truth. As Jaime mentioned, if you had a case where someone is saying they billed 24 hours, yet they're compulsively, posting onto social media or tweeting, that would undermine the credibility that they were actually, in fact, billing 24 hours, if that's even possible. Another specific example on credibility, I had a case involving a woman who was rollerblading in her neighborhood and fell on a unsafe utility vault on the sidewalk that hadn't been bolted down, and she essentially fell into the utility vault when she skated over it. The defense had brought a somewhat novel defense by saying they didn't believe that she was in fact injured on the vault, and that she had concocted this story that she was in fact there and was injured in some unrelated incident, and was using this as a way to find some sort of pool for compensation. In the case, during a client interview, I discovered that she did in fact have a GPS fitness function on her phone that was active. It was Map My Run, and it did record her rollerblading during that day. And so this was not, these are screenshots of the route she took, but we were able to provide it as actual confirmed GPS data to the defense. And in fact, if you plugged these into Google Earth, the GPS files, it would animate precisely her route at the same pace she was skating. And you could see her skate the route until she reached the exact point of where she fell. And that's where the recording essentially ended. You'll see there's like a straight line, like a hypotenuse on the left side. That's because the recording ended and it was connecting two dots on the map to finish the run. But it was really compelling evidence that essentially shot that defense out of the water. It was clear that she was in fact doing what she said she was doing. And you'll even see on the left-hand picture, it says inline skated. So she had entered it at the time that she was inline skating.
And it was really interesting when Nick and I were preparing for this presentation and he brought this case up, that it's a number of years old and that he discovered this data in subsequent discussions with his client, but that his practice has since developed where he believes if he had this case today, he probably would have learned about this data immediately upon intake. So that's why, I keep going back to you should ask about these things on intake. They really are so prevalent in our society now that this needs to be one of your initial intake questions.
Yeah, and that's a great seg into moving on from using social media proactively, offensively to prove an element in your case, to best practices to use it to protect your clients as best as possible. It is now our practice in the retention meeting with a client at the earliest stages of a case to talk about their social media. You have to know if you are doing it in your cases, attorneys that are diligent and, following, being aggressive in their defense, they're doing it to your client as well. So you have to assume it's working both ways, and you always have to be mindful of it. One thing that is playing off a common axiom is dance like no one is watching, love like you've never been hurt, sing like no one is listening, and post on social media like it will be introduced as an exhibit to your deposition. And it's a good rule to live by, because if your client is not careful, it will be introduced as an exhibit at their deposition. It has happened in my case, in my cases, especially before I incorporated that at my retention meeting. So the first thing to do when it's appropriate in that initial meeting is determine what is already out there. Jaime already hit on this when you're talking with a corporate client, but in an individual setting with an individual client, you should talk to them. What platforms are you on? Do you have a Facebook account? Do you have an Instagram account? Are you on Twitter? Are you a prolific tweeter? Figure out what's out there and then get it more specific. Is there anything out there that is specific to our case? Your contentions of liability against the defendant or your injuries. And some of them may be relevant to your case, even if they seem innocuous at the time. For example, if your client has photographs of themselves on a vacation, but it happened after an injury accident, that could be relevant evidence of their recovery. So if they're, trying to amplify symptoms during a case, and there are public posts of them, in Hawaii snorkeling after the incident, that would be a real problem. And you want to know what's out there. The first thing you also have to tell them is whatever is out there, you have to keep it. You cannot delete posts. It is unethical to advise a client to, delete anything. And it is also likewise, if your client did it on their own, it would still be a problem where you would likely face a claim of intentional spoliation, where you could face, fact or issue or even termination sanctions in the case. It is not unethical to advise your client not to post anything more, and I do that in my cases. Tell them if whatever you've done in the past, don't post anything related to the case. I'm not going to tell them not to post at all, although I do think it's a pretty good advice, because oftentimes, like I said, something that could seem innocuous could come back to haunt them. So maybe for them to take a step back from their social media activity, it's ultimately their case and up to them, but it is something I discuss with them. And it's not unethical to tell them to put their social media settings onto private. So if you have an Instagram account or a Facebook account, they can turn their settings, if they're on a public setting, to turn it to a private setting or a friends only setting, or whatever the appropriate terminology is for the social media platform. They just can't delete anything, but they can certainly make it private, and that probably would be something that they should do. The other thing
on that point, just wanted to point out that we're going to get into how you can obtain social media through discovery, written interrogatories, request production of documents, things like that. A lot of the social media is obtained that way as opposed to subpoena. We're going to talk about the differences, but when it comes to a court considering a motion to compel production of evidence, whether or not your client has the social media on private versus public will be very influential on the court's decision. And if your client does have their social media set to private, then the court is more likely to not order that the social media posts be produced. So that's an important part of the process when you're getting up and running with your client. Like Nick said, you can't advise them to delete anything, but you can advise them that they might want to consider making their social media private. And then that way down the road, if there is some post that they had made that might be harmful to their case, it's possible that the other side won't be able to obtain it because your client's social media was made private.
That's right. And the timing that most courts consider is the time that a subpoena or discovery request was served. So when your client walks into your office, if that discovery hasn't occurred yet, you have time to change that setting before the point in time where a subpoena or other discovery request is served. So it will, in fact, be private at the time the subpoena or discovery is served. The other consideration that we haven't yet mentioned is if you're dealing with the parent of a minor child, it's important to consider not only that the parent needs to, go change the settings on the child's social media as well, but that child may be using social media that the parent is unaware of, so that you need to advise your client to have a candid conversation with their child, or perhaps, depending on the age and circumstances, bring that child to a meeting with you so that you can have that candid conversation, so that you can discover where, in fact, a minor or teenager is posting. It might be to an account that you're not familiar with, a platform that you're totally not familiar with, a platform that the parent has no control over. So the child needs to be informed of the significance of social media and the bearing on the case as well.
Yeah, and that's, it's also important in that retention meeting to discuss having your client reach out to family and friends who may be intimately involved in their life. All of us have our, life cheerleaders, people who love us and want to have the best results for us. And some people get impassioned and will post about how angry they are that something happened. Your client needs to talk to those people, not to post anything either. That those posts of the dangerous ledge on that case, some of those photographs were from friends of friends of friends. So you can really go down a rabbit hole of discovery, and the same thing could happen to your client. So obviously they can't control what everyone in their life is doing, but often it's a very small circle of people in their life who would ever post anything relevant to a case. And for those people to be talked to by your client saying, hey, don't post anything more. You might want to put things onto private for a dependency of this case, and also not to delete anything. If those friends of friends were to delete anything, once again, you could face a spoliation issue. So now we're going to talk about how to actually get social media evidence in your case. The first thing that I often do, the first thing, just like the retention meeting, the earlier the better. Once a lawyer gets involved, the other side is going to be notified of the case, and they're going to have that exact same conversation with their client, whether that's a corporate client or an individual defendant. And they're going to have that exact conversation where they're saying, what's out there, set everything onto private. Hopefully they'll tell them not to delete anything. But your window for getting the publicly available social media may end very early, because what was available, what was public, suddenly disappears because it's been made private. So oftentimes, it always depends on where a case is in its, in its pipeline. But if I can do some discovery, informal discovery, pre-litigation discovery on what's out there in social media, it gets a jump on the case before things can be hidden from view. And this can be done just looking on the common platforms of Facebook, Instagram, and then expanding it outwards to any of the various platforms that Jaime discussed at the beginning of the presentation. The other way after the case is filed is through formal discovery. Now, Adam referenced the difference between propounding discovery versus a subpoena. Cases have been very consistent that subpoenaing directly from the social media provider, for example, from Facebook, Twitter, Instagram, any of the major players, you're likely to be prohibited, or they're going to be able to be shielded from that subpoena through something called the Stored Communications Act. You're going to get a case, the Facebook Inc. versus Superior Court case. That was a California Supreme Court case that talks in depth about the Stored Communications Act, or the SCA. But generally, the SCA has provided a blanket protection from these social media providers from providing any user accounts, unless it is a government inquiry for a law enforcement purpose. There's also some other specific exceptions. In that Facebook case, is the 2018 California Supreme Court case. This case involved a group of criminal defendants who were, I believe they were accused of committing murder, and there was a conspiracy charge and some gang related charges. And they were attempting to get information from Facebook, Twitter, and some other social media behemoths directly through subpoenas relating to the murder victim as well as to a prosecution witness. And those companies, including Facebook, they moved to quash the subpoena, and it worked its way up to the California Supreme Court. And the Supreme Court held that the SCA protected these companies from producing directly based on the Stored Communications Act. However, it did find that there was an exception that applied, and that the posts were made on a public setting at the time subpoenas were issued. And this fit within one of the specific exceptions. It was the lawful consent exception. So think of the police show up at your door, and we all remember from our constitutional law class, if you give them permission to enter, they now have consent. So any Fourth Amendment challenge is likely not to be founded in that case. Similarly, if you have your account on a public setting, you don't have the same privacy protections. And that's the same thing that Adam mentioned, that there is a legal significance to whether a client's settings were on public or private. Also, as Jaime mentioned, I believe, it is based on the time the subpoena was issued. So if at the time the subpoena was issued, their settings were on public, and then by the time it wends its way to the California Supreme Court, they put it on private, it doesn't matter. At the time of the issuance of the subpoena, the accounts were public. One other interesting thing on the Facebook case was the defendants also made a somewhat novel argument that because some of the posts were made privately, but to a large group of friends, that still fit within the lawful consent exception, because they posted it where, to hundreds of Facebook friends or followers on Twitter. So how could there be an expectation of privacy? The Supreme Court found that this was one bridge too far for the lawful consent exception. So long as you were broadcasting it to your group, it was still considered a restricted communication within that group, and was different in kind than a public post. So as you'll see in the case law, there is actual differences of public and private. It does matter. Moving on.
That's right. Another really interesting thing that I just found about that Facebook case, I hadn't read it before, read it fully before preparing for this, was that the defendant, the alleged murderer defendant, was a proponent of some of these subpoenas, at least one of the subpoenas, and he was making a constitutional argument that it violated his constitutional rights to be unable to get that evidence and defend himself. So he was making a very strong argument from a non-police or governmental entity, and that's the context where they made some of these rulings. So he was a private individual trying to get these rulings. Also, it wasn't just Facebook involved. I believe it was Facebook, Twitter, and a couple other big ones. And the positions that they took are discussed in there, and the fact that Facebook and Twitter and these other entities were proposing alternative methods of how you could potentially gather this evidence. So it's a case that's worth reading, even if you're just reading for, you know, the responses of these big companies. What kind of positions did they take? What alternatives did they suggest? Because they suggested many, and some of them the Supreme Court shot down as you know, too far removed from a process, or I think they did suggest that the individual defendant seek a warrant or something like that, and those were not well taken by the Supreme Court. But it's a very interesting case and gives you a lot of alternative options.
The other case was from a little bit earlier, but still good law. And this one goes in, it segs nicely into the use of discovery. This one, there was an allegation of juror misconduct. It was a Superior Court case in Sacramento County, and it was an assault case, and one juror basically whistle blew on another juror who was posting onto Facebook issues in the case, and in fact, crowdsourcing like the verdict, you know, what do you guys think? What should I do? That was at least the allegations. So the court was seeking evidence from the juror's Facebook account. It was not set onto public. It was a private to his friends, private setting. And the court that ruled, the Court of Appeal ruled that likely the Stored Communications Act would protect, I believe it was Facebook, from producing this evidence. However, the Superior Court was trying to compel the juror himself to produce it. And the court found that you could do this. It was appropriate for the court to compel the juror himself, not the service provider, to provide that discovery. And that's an important distinction because that's generally how we get discovery in our cases. It's through requests for production, not to Facebook, not to Twitter, but to the actual individual that holds the account. So it would be things like any and all posts that are relevant to some issue in the case. You want to make sure that your requests are narrowly tailored. So if you were to request any and all posts on your social media ever, not only are they likely to be objected to, but they're likely to be found as overbroad by a court. However, if they're narrowly tailored and the defendant or the opposing party refuses to produce discovery and you have to go seek a court order through law in motion, it is likely they will order that party to produce relevant information, just like in the juror number 1 case.
That's right. And if you get to the point where you are interacting with a social media giant like Facebook or Twitter, that's going to be their first response back to you, is that you should be seeking this discovery from the social media user and not from them. So expect that, because it's going to be their first response to you.
Other ways to get to discovery. Adam, you want to talk about this?
Well, before we move on to other ways to get to discovery, you know, the one time when a social media user cannot be reached is if it's a dead person. So finding the social media of deceased persons has special provisions. And so in California, we've adopted the Revised Fiduciary Access to Digital Assets Act, and it's in the probate code because we're dealing with a dead person. So you've now shifted from civil to probate jurisdiction. And it's important that act actually grants access to fiduciaries, trustees, personal representatives, and in certain cases, custodian of digital assets. So that it would be the person in possession of a deceased person's digital assets as of the date of death. So, it's a subset of persons. And if you are not one of those persons, if you are a defendant who is a non-fiduciary, then you need to be serving your discovery requests on the personal representative, on the trustee, on whomever has that access. So one way to figure out that access is, for example, since the passing of a few of these acts, and recently Facebook has created what's called a legacy manager, and the individual user, all of us for our accounts, can go onto Facebook and use the legacy manager to designate who will be the custodian of my records when I pass. pass my Facebook account. It's going to pass to somebody. You can either use the legacy manager, or you can literally write down your usernames and passwords. You know, in estate planning, sometimes we actually recommend this to our client. Write down your account passwords and put that piece of paper with your passwords, those passwords that you are never ever supposed to write down, put it in a safe deposit box somewhere away from your house, so that if your house burns down, that someone can go get these email addresses, passwords, you know, all of your things, because a big social media giant is never going to give that password out. So Facebook has a legacy manager. Google has an inactive account manager. And then on the other hand, Yahoo says that its terms of service does not provide for succession planning or any right of transfer. So, you know, depending on who you're interacting with, they'll say, when you signed up for this account, you didn't sign up for transferability, and we're not transferring it to anyone. And there is no one that has a right to this account. So that was one of the reasons that the RUDFA was enacted, to give someone the right to go get those. But even if you are one of those persons, if you are the fiduciary, you might still need to use a third-party subpoena to obtain the records of the deceased person. And these social media giants, especially Google, they really distinguish between financial records and communications. So financial records, there's a long history of banks producing records. And so Google now with Gmail and both Google Wallet and your linked accounts, they are actually more likely to give you access to Google Wallet than they are to an email account in Gmail. So know that in advance and know that you're up for a fight. If you do have to reach out to Facebook or Google, you need to go on their website and find their emails that directly link to these account services for deceased parties. You need to work with their counsel. If you are going to go get a third-party subpoena, which Google, for example, requires, you need to ask them for the language that they would like the order to say before you obtain the court order directing them to release the records. Because if it is not in Google's language, they will reject it. So be sure to work with counsel there. They are very familiar with these processes, and they are resistant and will shut you down in certain cases. So I think that's my computer ringing. I apologize. So that's social media of deceit.
So, you know, one thing that we've been talking about is just trying to generally discover what's out there. One tool that you may want to use is sending a special interrogatory to the party to ask for them to identify the accounts, ask for them to identify the usernames for social media accounts that they have there. You know, hopefully they don't get the advice to make their account private when you send the special interrogatory, but it's something you may want to consider. Another thing you may want to consider is getting a forensic company involved. And there's companies out there that will do this work for you, and you can get them involved at various stages of the litigation. One is before litigation, these companies can do your social media search for you. They're very good at downloading the information. I'm going to talk a little bit about laying the foundation, authenticating these documents and these social media posts that we all want to get into evidence. They're good at doing the download and having good presentation of how they got it, so the court will likely admit the evidence. These are a couple of companies that I've used that do these forensic search for you. They're not paying you or anything to put their names there. They're just good companies that I've used in various situations. And one example that I wanted to discuss was in a case, and this, while it involves text messages, which is not entirely social media, I found it to relate to what we were talking about. And in this case, we sent a request for production of a document for the defendant to produce his phone so it could be inspected. And that is obviously quite a request, but it was a case that justified it. It was a very serious case. It was a wrongful death, the case involving a drowning, and the defendant, there's an allegation of punitive damages. And we wanted to get to the defendant's text messages, instant message, direct messages on Facebook, things like that. So we asked that the phone be produced, and with defense counsel, we came to an agreement about what could be searched on the person's phone. And there was, we came to an agreement on keywords that could be used. And so we used these, a company, a third-party company, one of these companies, Archer Hall or Blackstone Discovery, I don't recall which one we used in that specific case, but they were able to download all of the messages on the person's phone. And that became very crucial evidence. And here's an example of what it looks like. I blacked out the phone numbers and everything, but you can see that there's an outgoing message at a certain time. It states when it was read. You can see here, he's saying, yeah, he's a good dude, agree. That's one of the text messages that was sent. So while this is not entirely social media, they were able to search for things like WhatsApp messages. These forensic companies know how to get into these phones and obtain posts and messages that the individual had sent. So that's one way that you can try and obtain some good material.
That's right. And another consideration there, if you think that there is a phone that you need, you can send out something called a litigation hold. And it's often used in corporate settings. It's used to basically ask them to turn off their email retention policy, whatever that policy is. If they only retain emails for 3 months, but you send a corporation a litigation hold notice, they have to suspend that policy and they can no longer delete the email accounts that are relevant. You can do this to an individual party if you believe that there's a phone. It arises a lot in trust disputes because someone has passed away and what is happening to that person's phone. And you tell the other side immediately that phone is subject to litigation hold and they cannot dispose of it, and they cannot delete it or wipe it or turn it into someone else's phone, right? That evidence has to be preserved. So you can send that out to parties whom you think have relevant evidence, and you can specifically name applications, social media applications that you want held and not deleted, not set to private. So think of all the tools in your box and think of, I love that he used a keyword search on a social media type platform, right? Because it's something that you use all the time in the context of emails. And you have to say, if you're talking about WhatsApp and you want to look at those, there's no reason that you can't come to the same kind of agreement and use all the tools in your toolbox, but apply them to social media settings.
We have about 10 minutes left. Before Adam talks about laying foundation, I just wanted to real quickly discuss about responding to discovery. So we've talked about using discovery, requests for production, special interrogatories, forensic searches to get social media discovery. You're also going to be receiving formal discovery requests. This is not, there's no one-size-fits-all approach, but it's always balancing a overbroad fishing expedition against a legitimate request for relevant information. There are likely attorneys who take the position, oh, my client's social media accounts, they're all protected under privacy rights under California Constitution. That's not likely going to be found or going to be supported if the case, if that issue is litigated further. But they're not, going to be obligated to produce non-relevant posts. So if your client has posted things that are relevant, and they ask for it, I think it's best practices just to provide it to avoid the unnecessary, law in motion. But there's definitely overbroad fishing expeditions. I've received requests that say any and all posts you've ever made. That's obviously overbroad. Or I've also seen a special interrogatory that says not only the names of the accounts, which would be appropriate, but the actual passwords to the accounts. So they want access to your client's accounts. That's way beyond the scope of discovery. And we always object to that when it's come up. So it's a balancing act. But my advice is to, on legitimate requests that are narrowly tailored, that you should respond to them.
And I would agree with Nick that providing your password to another party is never appropriate. That's beyond the scope of anything you will ever get in discovery. And as I said earlier, I don't think that any of the social media companies would ever provide a password in any context, whether deceased or not. So that's something that you're going to prevail on. The only time you might ever give access to a social media account or a phone would be how Nick described, in an agreed party where you're giving a vendor the phone and that they're going to forensically, image the phone. And in that case, you would have to unlock the phone or open the phone or whatever it is to do that. But that would be by agreement and probably with a third-party vendor.
So now that you're all thoroughly convinced that social media is extremely important by this excellent presentation, and that you're going to be using this in your practice, one important step, very important step, is getting this into evidence. And I'm going to go through ways that you can lay the foundation to get this social media evidence into court, into your trial. And we talked about doing early investigations yourself, going out there and trying to find what is available and doing it early on before it's made private, before someone deletes it, whatever it might be. And what you might find yourself doing is taking screenshots of things to try and preserve it, whatever it might be. And that's very important to preserve it. But when you go into court and you want to convince a judge that the post that you're trying to put forward is actually authentic, you're going to need to convince him that it wasn't doctored, that it wasn't altered. So one recommendation is, after you perform the search yourself, if it's not justified to get a forensic company involved because of the cost, or you just want to do it this way, you should follow up with an investigator. You can even walk him through the same exact steps that you took. Say, hey, go to this Facebook page, there's a post on this date, take a screenshot for me. So then later on, you can go into court and have the investigator testify before the judge. This is what I did. These are the steps that I made. I took a screenshot. This is what it looked like. That way you're covering your tracks and you can lay the foundation with an investigator, and it helps preserve the evidence. Another way that you can get the post or whatever it is, the tweet authenticated, is just send a request for admission to the other party, asking that they admit that it is what it's proposed to be and that they made that post or that tweet or whatever it might be. And one thing that I commonly do is take screenshots and present it to the person at their deposition and ask them, did you make this post? Is this your Facebook? Does this appear to be your Facebook page? Whatever it might be. And so you can lay some foundation for the court later on when the court goes to rule on whether or not to admit the posts into evidence. So I'm going to go through the evidence code that covers the authentication, which is really the key step. I mean, obviously you might have to deal with things like hearsay and things like that and normal evidentiary objections to the content itself. But authentication is extremely important when we're talking about social media posts, because judges know that this type of evidence is easily altered, easily edited, easily fabricated. They know that somebody can take a post and modify it and make it say whatever they want to say. So you want to put forth enough evidence to convince the judge. And the standard is as follows: introducing sufficient evidence to sustain a finding that it is the writing the proponent of the evidence claims it is. That's why I was talking about earlier, getting an investigator who can get on the stand and testify under oath of the steps that he made, identifying this was the person's profile, whatever it might be, and convincing the judge that the writing is what it claims to be. We talked about requests for admissions and getting the deposition testimony. A piece of evidence can be authenticated by anyone who saw the writing made or executed. So when you get the person who made the post itself to state that they made that post, then under evidence code section 1413, then you can authenticate the item and get it into evidence. And there's no limit to how it can be authenticated. So get creative, make sure that you're going to be able to convince a judge. At the end of the day, it's the court's discretion about whether or not they're going to admit the evidence. So keeping in mind that a judge might be skeptical that something could be edited and wants to make sure that it's authentic, just make appropriate steps to be able to convince a judge that it's authentic.
So That concludes our presentation. This is a ever-evolving area of law. The social media landscape, as we've referenced a number of times, is constantly changing, but you have to be mindful of using it in your case, because if you're not, you're really litigating your case with one hand behind your back. So hopefully we've been, informative on this issue, and we hope you have a great rest of your MCLE spectacular. Thank you.
Hello, everyone. I'm Ann Wolf, the Education Events Director for the Contra Costa Bar Association. I want to thank Nick, Jaime, and Adam for this really very fascinating and timely program today, and for sharing your expertise and your research with us. I also want to thank the Litigation Section Board for helping to coordinate this program. I certainly will be considering any posting that I do as a deposition exhibit. Yes, thank you, Nick, for that. That should be something maybe all the teenagers should hear too. So you are now all invited to join a live Q&A session with Nick, Jaime, and Adam. Below the screen on which you're watching this session, there is a link that will take you directly to the live Q&A session. But first, a couple of announcements. As a reminder, the materials and evaluation forms for this program can be downloaded from this session page. There is a tab above the chat that says Files. Everything's in there. If you'd fill out the evaluation form, you can email it directly to me. That would be great. Your attendance certificates, they will be available within the next several weeks. If you are a CCCBA member, your attendance certificate will be on the website in your member profile under My Events tab. If you are a non-member or would like more information on how to get your attendance certificate, please see the information included in the FAQ tab. So coming up next at 10:30 after the break, you can either learn how to calm your brain and regain your focus, or you can get tips on how to avoid coronavirus discrimination at work. Those concurrent sessions will be followed by a 12:30 keynote of Novella Coleman on examining racial bias at the intersection of housing and policing. At 2:30 this afternoon, please join us for the live law firm marketing forum with Cara Pryor of James Marketing Amplifier and our own Terry Leone and Erica McKenna. Also, don't forget, from 1:30 to 3:30, the sponsor meeting rooms and the section networking meeting rooms are open. For any and all technical difficulties, head back to that FAQ tab and you should be able to get some help there. Now, please click on the link below and join the live Q&A session with Nick, Jaime, and Adam. Hope to see you there. Have a great rest of your day.